either one of you lawyers. Yes, David here, he's been practicing law since 1987, and he's practicing law on civil litigation, real estate law, construction defects litigation, probates, and so on. And he's been doing presentations on tenant and landlord relationships during pandemic. So we're gonna talk specifically about that today, and David is gonna present it tonight. Oh, okay. So I can just start by introducing myself. So if we go to slide, if it's possible to slide, let's just start. So introducing myself. So I'm a realtor specializing in Northern California, and I'm organizing multiple webinars on different topics, since we have buyers and sellers and there is different matters. So I always try to educate my buyers and sellers. And please, if you have any questions regarding real estate, like you can ask me questions later, but today we're going to talk specifically about tenant and landlord relationships. We can go next slide. Okay, so should we start, or are we ready to start?
I'm happy to start, but I don't notice whether we truly are on Facebook Live. I see it on my website here, but I don't see it on Facebook itself. And I wanted to see if we could start sharing it on Facebook.
Yeah.
So it's not popping up yet. And I think the best way, I'm seeing questions pop up. I'll be more than happy to answer those questions after the presentation, because I may, during my presentation, answer the question. And if the question's still pending, it's an opportunity for me to emphasize something that may have been missed during the presentation.
Yes, true. Like, please ask the questions, and we're gonna follow up with questions after the presentation. Are we live? Yeah, okay, we're live. Can we start? Yeah. Yeah, we can start, yes.
Very good. Whenever you're ready, Lily.
Yeah. Yeah, we're good to go. Hi, so today we're going to talk about landlord and tenant relationships during pandemic, and we have David, who's been practicing law since 1987, and he's representing real estate law and civil and so on. Please welcome David, and I'm just pass it on to you, David.
Thank you, Lily. I've known you for a number of years. We've had a common connection with Yoko's in Fremont, and I'm a lifelong resident and happy to present on this topic. I've been doing so since the pandemic began. My first presentation was actually on April 9th last year. And so as the pandemic sadly has continued, the laws have evolved over the last year, and there's been some very recent developments. So if you don't mind, if we could proceed with the slides, and we'll go slide by slide. What happened a year ago is helpful to understanding where we are today. Back in March of 2020, the governor declared a state of emergency based on COVID, and he did something very important. I've been practicing law, as you mentioned, since the 80s, and landlord-tenant relations have been governed generally by state law, with some exceptions for just cause or rent control. But the rules upon which you could evict a tenant were exclusively under state law. But because of the emergency and the desire to have tenants remain in place so that they wouldn't cause community spread, the governor gave local control to come up with some moratoriums at the city and county level. And on April 6th, the California Judicial Commission stepped in, and that's made up by the state Supreme Court Justice And the California Judicial Commission said, we're going to just have a statewide ban, and we're going to prohibit all evictions with limited exceptions. So from basically March and through September, you had all these moratoriums in place, but the state came in and said, we're just going to have a statewide ban, and we'll figure it out. Next slide, please. I mentioned the fact that the governor did execute or issue an executive order that allowed the cities and counties to authorize moratorium bans. Primarily tonight, we're going to be talking about residential moratoriums, but because we have some people here from Fremont that are interested in the commercial market, I'll improvise and talk about our Fremont commercial ban as well, because there may be some local interest in that. The governor has extended local authority for imposing commercial eviction bans to places like Fremont through June 30th of 2021. But with the passage of AB 3088 in September of last year, the state for the first time really began to set statewide standards for the circumstances in which a landlord can evict a tenant or accept less than 100% rent. Next slide, please. September 1st, 2020, the legislature passed AB 3088, which is called the COVID-19 Tenant Relief Act of 2020. You'll hear it referred to as CTRA or CTRA. But in Alameda County, we had passed a moratorium ban countywide that applies to all the cities in Alameda County, including Fremont and Newark, that predates CTRA and is still in effect. The CTRA law is the law unless the county enacted or renewed its ordinance before August 19th. Alameda County's ordinance survives CTRA. And I'm getting questions in real time. Jason, I see your question. We'll hold them off until the end. You can certainly ask them now, but we may go through them. To answer your question, Santa Clara County's moratorium for residential moratorium was passed on August 25th of 2020. It was too late. It did not survive CTRA. So CTRA controls in Santa Clara County, Alameda controls in Alameda County. Next slide, please. Alameda County, if we're here and you have property in Alameda County, you need to understand the ordinance. It applies to residential countywide for tenants who qualify for COVID-19 tenant relief. Alameda County has deferred rent for 12 months. So if you had rent due in April of 2020, you can't collect rent or ask for rent until April of 2021. And so the extension goes all the way up to March 1st of 2021 for another 12-month extension. Eviction ban remains in place until 60 days after the county health emergency expires. The county health emergency is the COVID health emergency that's very much in place. There are some limited exceptions to the ban in Alameda County. If you are removing your property from the rental market, and in Fremont, you can do that without going through a complicated process that exists in Oakland, which is called the Ellis Act, where you have to give notice, but that has to be adopted by the local jurisdiction. If you're removing it and want to sell it, you can proceed with an eviction unless there's other moratoriums in place. Or if somebody's committed an imminent threat to health or safety other than COVID-19, somebody's conducting a meth lab or engaging in criminal activity, or there's some other health hazard, you can go in for a limited exception. There's also, I should say, in Alameda County, a separate local rule of court, which limits the ability of somebody to go in for an eviction. So you need to be familiar with the local rules of court, Alameda County rules, and how those two interplay. Next slide, please. The CTRA, talking about Santa Clara County and outside of Alameda County, does not apply to commercial tenants. The CTRA that was adopted in September 1st looked retrospectively back to March 1st of 2020 through August 31st, and then prospectively at that time through the end of February of 2021. There's two periods that we're going to talk about. The period of March 1st through August 31st, 2020. You're going to hear me talk about it as the protected period, and that's going to mean something. September 1st to 2020 to January 31st, 2021, that's a typo, was the transitional period. And there are different rules depending upon those periods of time. You're also going to hear about high-income residents. High-income residents can apply for COVID relief. And if they submit adequate documentation, they have to earn at least under 30% of AMI. They must provide proof of income, such as a tax return, a W-2 or pay stubs. But if they were in a high-tech industry and lost their jobs, they too can qualify for COVID-19 relief in the deferment of rent. There was an informational notice that had to go out back in September to everybody to notify them of the new rules. We'll talk about that later. Next slide. More highlights of CTRA. As I talk about CTRA, it applies with equal force to SB 91, which is the most recent rule. It has become very form driven, as the notices that you have to give out or the eviction notices have to have mandatory statutory language. So if you don't have the language and you try, if you're a landlord and try to evict a tenant and haven't followed the statutory mandatory language, the court will dismiss your case if you go to court. Fortunately, the state is finally catching up with the fact that the statutes are passed before the forms are generated, and they're now providing those forms online. And I'll give you a few sites in the chat box towards the end of the presentation. If you're a member of the California Apartment Association, they have their own forms, and I've done this presentation before California Apartment Association. So you may see the reference here, like the informational notice is form CA 400. That's for the CAA, where they generate their own forms. Again, you have to provide them information as to how the process works. There was a special form that is required and still required for unpaid rent for the protected period between March 1st, 2020 and August 31st, 2020. There is a separate notice that has to be given for unpaid rent between September 1st, 2020 and January 31st, 2021. And what CTRA started in September still applies, which basically is you send out a notice, you send out to somebody, a tenant that hasn't been paying rent. If they're still not paying rent, you send them the 15-day notice to pay rent or quit. That 15-day notice allows and must include a form where the tenant has the opportunity to declare hardship under penalty of perjury. If they're not a high-income tenant, as I described before, and they don't earn 130% of AMI, but they're simply saying, I can't afford it, I've lost my job, my childcare expenses have increased. We've had somebody that's had a COVID and our medical expenses have increased. It's just a form. You can't ask any documentation to support the form, but they're doing under penalty of perjury a statement to you that they can't pay. If they give you that statement in the right amount of time, then all you can ask for them is to pay 25% of the rent that's due. But that's a term of art, and we'll get into it when we talk about SB 91. It's not just in that 1 month, it's 25% cumulatively. So they could not pay you any rent for, in this case, when CTRA was in effect, for September, October, November, December, and January. And on January 31st, they could pay you 25% of all the rent that was due for that 5-month period. If they pay you that rent, what happens to the unpaid rent? Well, they treat it as consumer debt like they do in Alameda County. They've converted unpaid rent not to something that can be used for a 3-day notice to pay rent or quit, or even a 15-day notice to pay rent or quit. The 75% that they don't have to pay during this period of time, a landlord will be able to collect in small claims. So it shifts very significantly rent, dividing it up between what is COVID rent, which is the 25%, versus the 75%, which becomes a consumer debt. And SB 91 extended these dates beyond February. We'll discuss. Next slide, please. AB 1482. One of the last seminars I gave before the moratorium was in February at Toll Brothers in Fremont. Had a great presentation on this new law that provided statewide just cause eviction limitations for landlords in cities that did not have just cause, as well as rent caps in cities like Fremont that neither had just cause nor rent caps for rent. There were certain protections that were going to apply if the house was more than 15 years old, if there was and it wasn't exempted because it was a mom and pop residential property and you did certain exemptions. Well, AB 14982 now applies across the board, and SB 91 applies it across the board, even with those limited exceptions. It limits no fault substantial remodel to compliance with habitability. Under AB 1482, if you wanted to remove a tenant because you wanted to remodel it and have vacancy decontrol and relet the premises new and improved with a new kitchen counter, a new remodeled kitchen, that's a substantial remodel. As long as you pulled a permit, you could do that. Under CTRA and under SB 91, that limitation, that exception has only been limited to instances in which basically a public agency says you've got a dilapidated house, it's not up to code, we're going to red tag you, you got to improve your property or else we're going to declare it a public nuisance and do terrible things to you. So basically they've cut out that exception. You can't utilize that as an easy out from the rental market. September 2nd, they opened up the courts for just cause eviction other than rent non-payment. Back then they opened up for non-payment evictions. And I did see, I don't know, was Mr. Rosenberg or somebody did talk about CDC, and I'll talk about that in a minute. SB 91 extended the cases that could have been brought under CTRA for the 25% rent all the way up to June 30th. So July 1st may be the earliest date. If somebody qualifies, if you have a tenant that says, I've got COVID relief hardship and I can't pay 100% of the rent, that the earliest date, if they pay 25%, would be July 1st to go back to the normal, so-called normal obligations to pay rent or quit. Next slide, please. SB 91, Senate Bill 91, was enacted on January 29th, 2021, and it extended CTRA through June 30th, 2021. And that's the law that we're currently under. When Ms. Garipova was advertising this seminar that she was talking about SB 91, that's where we are today. And extends the moratorium really if somebody qualifies through June 30th, and now provides new rental assistance programs, which we'll discuss about later. It also provides some new tenant protections. This one I'll talk about several times, but it creates a new state rental assistance program, which is the 80-20 rule. And 80-20 means that if the landlord and the tenant work together, and they're going to be encouraged to work together to obtain rental assistance, that the landlord can get up to 80% of the rent and must forgive the other 20% if the tenant gets state rental assistance. So if you had a tenant going back to March that owed you $1,000 a month, you could go back and collect that, but you could only collect $800 for each of the months that they were behind, or up to 80% of the rent. And at that point, you forgive the other 20%. That's the deal. Okay. And again, they also created a new landlord notice that was supposed to be sent out on February 28th. I am mindful that this is a month later, so it's in fact late. And again, it's one of those things that the legislature does, and they're sitting around, and you have the California Apartment Association and some of the stakeholders, and certainly the tenant organizations that are very, very familiar with the rules. But if you're just a mom and pop landlord and you don't have access to these resources and you don't have an attorney on retainer keeping you advised, this is one of these got-you mandatory provisions that arguably you can't make up after the fact if you didn't give the notice out to tenants that weren't paying rent about the fact that there's this new SB 91. So I'll talk about that again. My view of it, as I mentioned earlier about these mandatory forms, is I would use them I would send them out in connection with a tenant if you're going to go through the process of trying to collect rent if they haven't sought COVID relief before, and then basically go to the judge, says, look, I didn't know about this form, but I provided all the protections SB 91 was supposed to give the tenant. I gave the right notice. I allowed them to do a declaration of hardship. They gave me back their declaration of hardship. I haven't accepted more than X amount of rent. If you're in that lane, I don't think that if there's a subsequent failure of the tenant to pay rent, that the tenant was obligated to pay, and you cooperated in trying to get rental assistance and do all the right things. I would hope that a judge wouldn't play gotcha, but you can be assured that a tenant or tenant's attorney will have a checklist and say that if you didn't do this by February 28th, no matter if you did everything else right, you're going to have the case dismissed. So we'll have to see how it plays out. Next slide. Non-payment of rent. Again, from now extends the period of time through June 30th of 2021. There's two kinds of rent. Remember I mentioned the 3/1/2020 to August 31st, 2020 was the protected period. Why is that significant? Because if a tenant gives you a declaration for that period of time and in response to non-payment notice that you properly served with the right form, that rent will never become due as a basis for evictions. They're protected. So for basically 5 months, the state legislature says you can't use the non-payment of rent from March 1st of 2020 through August 31st of 2020 as a basis for an eviction to try to reclaim possession. You can, however, collect it as you can with the 75% rent for the transition period beginning on September 1st, 2020 up to June 30th, 2021 as a small claims action. Okay, so the protected period means that non-payment of rent is converted essentially to consumer debt that you have to recover, if ever, through small claims, never the basis for a 3-day notice or 15-day notice to pay rent or quit. And beginning September 1st, now all the way through June 30th, we're now into the 25% rent, and no more can be collected from the tenant unless you get state rental assistance or local rental assistance. 15-day notice. This was true then. It's true now under SB 91. It's not 15 days like you and I might count 15 days. The 15-day notice for the tenant to be able to return the declaration of hardship invoking COVID relief is measured from the day after that you sent it. So if you send it out on March 1st, the first day to count 15 days is March 2nd, but you cannot count weekends or holidays. And so it's theoretically possible that if you have like during the Christmas period, it could have taken more like 30 days before the 15 days runs. You only count actual days that that's neither a holiday, like today, for example, was I believe Cesar Chavez Day. This would not be a day you could count towards the 15 days. It's a state court holiday recognized in California. And then again, Saturday and Sunday you couldn't count. Tenant cannot be evicted if the tenant timely returns declaration of hardship. That basically creates this moratorium that would extend all the way now to June 30th. They have the 25% rent payment. So I give the example of somebody paying $2,000 a month from September 1st of 2020 all the way up to June 30th. That's 10 months. That's $20,000. They could pay you $5,000 on June 30th and come up within the 25% rent to prevent you on July 1st giving them a notice of eviction. So it's a real or to proceed with eviction because you've given them the notice before. You now have a situation where the other 15,000 or 75% of this of the 20,000 over that 10-month period is now consumer debt. You'll have to go to small claims court, and you can't go to small claims court until August 1st. The other thing that people that understand small claims say, well, how can you go after somebody for $15,000 of rent? Small claims against a person is capped at $5,000. Well, part of the CTRA and SB 91 legislation was to eliminate caps on small claims for landlords to collect rent against tenants. So I can imagine on August 1st, small claims courts up and down the state are going to be deluged with landlords that are going to try to collect the 75%.
Oh.
Go ahead. Oh, AB 1482, just cause expansion. Under CTRA, that under CTRA is now extended in SB 91. Again, they have to violate something other than the rental obligation. If you're removing property from the rental market, you have to state the reason why. There's some limited exceptions, but virtually every property is covered by AB 1482 during the pandemic under SB 91. Next slide, please. Here is a form, and I know, Lily, I don't know how you handle it. I don't have any pride of authorship on this. You're free if anybody wants to ask for a copy of this. They're entitled to my PowerPoint. I'll share it broadly. And so I know this is hard to read, but this is the 15-day notice that now exists under, oh, thank you, under SB 91. Look at the rent period from September 1st, 2020 through June 30th, 2021. So you'd have to go down. Notice is given, and within 15 days, again, not including Saturdays, Sundays, or other judicial holidays, after service of you on this notice, you're required to pay rent described, complete and sign the attached declaration of financial distress, or surrender or move out of the premises. So this is very itemized. And then you have to give payment instructions and how payment can be made. If you can accept electronic funds or cash, if that's permissible. And then and this is really a notice of what happens if the tenant doesn't do what they're supposed to do. Okay. So this is a form, all 4 pages, and then it's the 4th page on the lower left-hand side here that continues on. And it says, and we'll be transitioning, you may qualify for rental assistance, okay? And we'll be talking about the website, housingiskey.com, or calling the 1833 number, and I called it this afternoon to kind of test it out, and I'll explain that a little bit later for you. So let's go on to the next slide. Please, because this is what the tenant has to deliver to you within 15 days of you giving them the notice to pay rent. This is an important document for the tenant to be subject to the protections that he's entitled to receive under SB 91. And this is it. You know, all he's saying is because of one or more of the following, all he has to do is sign under penalty of perjury, and you have to take it at face value unless it's a high income earner, and that's kind of problematic. But if you know that somebody was drawing down low to mid 6 figures for whatever reason based on their application or credit history, and they're claiming COVID relief, then you have a right to say, well, I think you're a high income tenant. You give them a separate notice, and then you're entitled in that instance to collect documentation. But here, all you get from the tenant is the mere declaration. If you're in Alameda County, basically they don't have to provide any written document. You can get documentation, but it's very much deferred if the tenant wants to defer it for many, many months after the mere statement that they are subject to COVID relief. So there is very minimal documentation. The declaration is it. You can't second guess it. You can't interrogate them. You can't say, well, I saw them applying for unemployment assistance and getting this and that. I think they can pay. You basically have to take it on faith. Next slide. So again, tenant debt collection, I've talked about it already, but I call it 2 kinds of debt. There's the COVID rental debt, which is the 25% if they've invoked and submitted their declaration of hardship that I just showed you within 15 days. That's their rental debt, but they have until, it's cumulative, they have until June 30th to pay 25% of all the past rent due to invoke protection against eviction. And 75% of the rent is deferred and can only be collected through small claims. As I said earlier, it can't be done before August 1st. Regular unlawful detainer actions for rental debt for not payment, not until 7/1/2021, unless you're in the instance where you had filed an unlawful detainer before October 1st, 2020, under the old pre-CTRA rules, and that the tenant would not have qualified for rental assistance at the time. Next slide, please. This is the other key feature about SB 91. One talks about extending CTRA, the 75-25% rule on rent deferral, going through all of the moratoriums for a tenant that is protected. So it really is CTRA extended through June 30th. But SB 91, we'll talk about some additional tenant protections, but SB 91 also provides an opportunity for rental assistance. Before you go in as a landlord and try to evict a tenant for non-payment of rent, you should show good faith effort investigating rent relief, that you sought governmental or third-party assistance, that you cooperated with the tenant in seeking relief. And it applies both to the non-payment of 75%. If you're trying to collect that, if for some reason all you did was try to collect the 75% for non-payment and you weren't using it for an eviction, you're going to have to show the same thing in small claims court, that you tried every which way to try to get federal assistance or state assistance to reduce the amount of past debt due. One of the things that's true is that if it's after June 30th, I'm saying outside Alameda County because the moratorium in Alameda County is going to go as long as 60 days past the lifting of the emergency in Alameda County. But if you're outside, if you're Santa Clara County and you can go into court on July 1st, and the tenant has never given you the declaration of hardship, you could say, okay, I've got an open season to collect all the rent past due. He didn't try to get protection for 75% of it deferred. He didn't pay the other 25%. He blew me off. So you serve the 3-day notice on July 1st. And there may be other notices that you have to do, whether AB 1482 applies then or not to your property. But assume you go through the right process to serve him, and then he doesn't pay then, and then you go to court with the unlawful detainer. You serve him with the unlawful detainer. The tenant has 5 days to respond with an answer, or else you can take a default. That's the olden days. Well, under SB 91, they could say, I wasn't really with the program as the tenant. Now I realize I am subject to COVID relief. I'm going to submit my right to C-19 COVID relief now, my declaration of hardship. And so they get a second bite at the apple. And at that point, that could be a basis for dismissing the case or getting them on a payment plan or doing whatever. So it's a hearing that would be held before they moved on. So you may think that you have the right to collect and evict, but if they're entitled to that protection, the court could fashion an order where the 25% can be paid within a certain period of time, and you'd have to start all over and see how they're doing for July's rent, August rent, and going forward. So it's going to be a really tough way to navigate through the process to try to evict tenants. Let me make a kind of disclaimer now. I should have done it at the beginning, but I'm going to do it right now. I'm not giving legal advice. I'm giving an informational talk. Okay, if you have any drill down questions, I'm going to give you my best answer based on my understanding, but this is a seminar. You're not paying me for my services here, so I'm just giving my best presentation I can, but that's my disclaimer that it's not intended to be legal advice that you can rely on. If you want to call an attorney afterwards or call me and establish an attorney-client relationship, that's different. The second thing that I want to talk about that I should have mentioned earlier, but permeating all of this, you're saying, I'm a landlord, I've got no leverage. The tenant's got all of the chits. I've got nothing. I'm losing, I'm not able to pay my mortgage on the house, my residential property, my investment property. This is not fair. Well, in a broad sense, I'm not going to argue with you. One way of understanding where this is coming from, yes, tenant advocates are building in protections for their for tenants up and down the state. That happens politically. But secondly, what's permeating in all of this is to try to avoid massive delocation of tenants because of COVID that can't pay. We want to reduce community spread. So tie goes to the tenant staying in their home during this pandemic. And, you know, yes, we are in a position now we're now in a pandemic, and yes, we're having more vaccinations, and by April 15th, apparently everybody over the age of 16 will be eligible, even if they don't have any underlying conditions. Great news. But today, just as a cautionary note, as we're experiencing this wonderful period where we have the vaccine perhaps containing it in California, in France, they're going through their third lockdown. They announced this earlier today, for 4 weeks, closing all the schools. So there are new variants in France. There's one in Brittany in Northwest France that they discovered. So there's going to be this constant tension between variants and vaccine. And as long as there's uncertainty, there may be happy talk in the short term, but I would expect, as we did back in March, as we did back in September, as we did back at the end of February, that June 30th is going to come and go, and we're going to have a real hard look as to whether those protections are going to be extended further. And so June 30th, I would, draw a line but I would not put it in permanent marker that this is going to be the end of tenant protections and tenant relief. Next slide, please. There's two classes of tenants going forward. Those that gave the CTRA or the SB 91 hardship declaration that I showed you, that one-page declaration, or the high-income tenants, which have another form that I haven't provided here that is available. There are tenant protections. If you're a CTRA hardship declaration, you can never collect late fees, whether unpaid before or after the declaration. Late fees are off the table as far as ever ascertaining what rental, even if you call late fees rent for purposes of late rent for a 3-day notice, whatever the contract says, the law is going to override that and say you're just basically built in only to your base rent and nothing more. You can't increase or charge for new fees for services. Let's say you provide, you have a multi-unit complex and you charge, $15 per month for parking. Well, you can't jack that up to $150 per month as a backdoor to try to increase rent. You're limited to the $15 or internet connections. Somebody has a CTRA hardship declaration, they're really frozen in time in terms of services and the inability to collect late fees. There are tenant protections for all tenants, regardless of whether they gave you the hardship declaration or not. You cannot apply security deposit to unpaid rent without the tenant permission. Even if the contract allows you to do so during the tenancy of the lease, you have to get separate permission now. A rent payment must be applied to future rent, not past rent due. And this was an open question when I was giving the seminar under CTRA, and it's been clarified under SB 91 in a way that I predicted it ought to be, or how a court might apply it. Let's say you have a tenant that hasn't paid rent for January, February, and March, and then they pay you for the first time in April. Well, apply to the April rent. Don't go back in time and say you got to keep catching up. The idea here is to encourage tenants to pay to maximize the amount of protection that they may be able to get for unpaid rent that was past due, to make more of it subject to the 75% rule, to get up to that 25%, to make it more consumer debt that you have to collect through small claims rather than the basis for unpaid rent for eviction going forward. You can't use past COVID-19 rent problems as a negative screening for new tenants. You're going to have people moving around. Maybe they got a new job. There's some activities, some of the reopening, and you find out from the last landlord, gee, they invoked COVID-19. They were not paying any rent after March. They just blew us off, but they gave us the declaration we had our hands tied. Well, you can't use that as a screening criteria. That would be discrimination. You cannot assign rental debt to a collection agency until July 1st, 2021. And you can never do so. I didn't word this properly, but you cannot do so ever for tenants who qualify for rental assistance. So if you start getting rental assistance from the tenant, then you cannot assign any of the rental collection. You want to encourage tenants. The state wants to encourage, maybe you don't, but the state wants to encourage rental assistance to decrease the burden and eliminate rental debt from the tenant going forward. Next page, please. Here again is the new state rental assistance. And I'm gonna, again, I'm gonna try to use the chat bar in a minute here to add some links for you. There's a new state rental assistance program that went into effect in March. In order for the tenant to qualify, they must make 80% or less of an area median income. One person in the household either qualifies for unemployment benefits or has financial hardship or increased costs due to COVID-19. Or one person in the household has risk of homelessness or housing instability. There's past due utility or rent or unsafe living conditions. The state is making them available in 3 rounds. The first round is to those tenants that earn 50% or less of area median income. And area median income is established statewide by the Department of Housing, but it differs in each community. Alameda County has a different AMI than Santa Clara County, which both have a very different AMI than San Joaquin County or Modoc County, where you have very different income streams. The second round of funding will be to communities disproportionately COVID impacted. To me, I read that as basically LA is going to go. As with a lot of state programs, if you're in Fremont, you feel like all the county resources go to North County. And if you're in Northern California, you feel like all the state resources go to Southern California. They've been disproportionately impacted. So in a sense, I don't want to make people more upset, but one way of negatively looking at it is we in the Bay Area have masked up, we've social distanced, we've done everything, and we've stopped community spread. Whereas in LA, they were less attentive to these social distancing rules. They've had more COVID impact down in Burbank, down in Southern California, and now they're going to get rewarded, quote unquote, with more state relief for their tenants than we were up here. Then the third round is up to 80%, 80% of AMI will be the third round of funding to the extent it's available. I'm going to put in the chat bar the following. It's housing, basically https housing.ca.gov. If you go to the homepage, there's an interactive app for you as a landlord. You'll see on the forms, housing is key. But if you do that, there you go. Very good. Thank you, Lily. Who ever did that? Or maybe I didn't. Did you do this, Lily? Thank you. Beautiful. This is real time. We haven't practiced this. But if you look here, there's an interactive app. If you're a landlord or a tenant, you can figure out what do you think you might qualify. There is a whole section here for tenants, eviction protection forms that they're going to have that declaration of hardship. You have eviction protection forms that you need to be aware of if you're a landlord. And then you're going to go to local governments. And what I'm going to talk about next is Alameda County. If you're not in Fremont or in Oakland, I'm going to put this in the chat bar. This is where you would go to see rent relief in Alameda County. Okay. And it's ac.housingsecure.org. And that applies. Are you getting us in there? Beautiful. Thank you, Ms. Garipova. Beautifully done. That is what applies in Alameda County. But look at if you can read the screen here, it's only to tenant households making less than 30% of area income. Okay, so it's even a narrower subset. And then in Fremont, we have, if you have a renter in Fremont, we have our own program here. And I'm going to put that in the chat bar. Okay, it's called Fremont.gov, Keep Fremont Housed. And it's a Fremont program that is coming into effect, which also is interesting. So let me just talk. I'm going to go off the slides here, just kind of talk freelance here. There's statewide rental assistance, but it only applies if you're not if there's not local assistance otherwise available. So option A exists for the statewide rent relief if there's no option B. Well, if you're in Alameda County, but not in Fremont or Oakland, Alameda County is your option B, so you need to apply at the county level. If you've got renters in Fremont or Oakland, you got to look at what's happening in Fremont or Oakland. And I know that somebody was asking me about Santa Clara County. I haven't drilled down to Santa Clara County, except when I was looking at the Housing is Key or the housing.ca.gov website, they'll list the local jurisdictions that have their own rental assistance programs. I didn't see any in Santa Clara County yet. I did see one in Fremont and one in Alameda County. So if you have a renter in Fremont, you have to apply only to the Fremont rental assistance. It's 7.1 million. Look at what they do here. Household is below 80% below. They have to follow the SB 91 guidelines. If you're not in Fremont, Oakland, oops, you're going too fast. Go back down. Oakland residents comply on the City of Oakland website. So there's Oakland's program there. So you can jump around and figure out what's happening. So you're going to be basically driven to the pot of rental assistance in your local jurisdiction if you've got it, rather than the statewide assistance. So fantastic, Lily. If we can go to the next slide, please. And that's good because it'll be on the chat bar. You can share that, and then they can do the website search. Okay. Landlord and tenant can apply for funds. Basically, you're going to have to do a declaration showing that you try to apply for it. Applications for state funds opened March 15th. They've opened up now in Fremont and Oakland, Alameda County. Up to 80% of past due rent from 4/1/2020 through 3/31/2021. You can apply for it. I think I saw one that said March. Some seem to apply for past utilities. They differentiate utilities that the tenant needed to pay that they haven't paid. That may or may not be a pass-through for you. That may be something that they've got to deal with, but they're entitled to get that assistance. Now, this is the hammer. Landlord says, I don't want to deal with all this government bureaucracy. What the heck? I just want my rent. Well, you can be that way, but they've created a real strong disincentive. If you refuse to apply for rent, the tenant can apply and get rental assistance, and they can even qualify. But you're restricted to only getting 25% of that rent. Okay, and you can't turn it down, because to turn down rent from governmental assistance would be a form of source of income discrimination. You can get in trouble for doing that. So you've just managed, by your stubbornness and refusal to play, waived 75% of your rent. And again, keep in mind that if you go to small claims trying to collect the 75%, and this tenant says, look, he refused to get rental assistance, you may be out your 75%. So are you going to try to reduce your rent by 20%, forgive it for the tenant to get the 80%? Or are you going to restrict yourself to 25% of rent potentially as your cap from your tenants in order to collect rent? I think the math is pretty clear. The economics are pretty clear. All the incentives are to try to get the rental assistance. And again, state funds available to landlord, state funds unavailable to landlord to reduce rent due from a former tenant. I had a landlord that called me the other day, and I had seen one of my prior presentations, but hadn't listened to this. Tenant moves out, let's say in March or February of last month. They move out, and they didn't pay rent from March through February. And so, well, I'm a landlord. I want to get statewide assistance to give me relief for all the rent I didn't collect. The rent is not, the assistance is not available for past rent for a tenant that is out of possession. Keep in mind the overarching social policy goals or public policy goals that SB 91, the stimulus money from the federal government is trying to do. They're trying to keep people in place. So the incentives, the assistance is a carrot to landlords and tenants to stay in possession, that they don't have to move out because they can't pay. Somebody that's already moved out, whether voluntarily or whatever the circumstance might have been, is potentially available for small claims collection, but they're not going to incentivize the landlord for a tenant that didn't pay, and we're going to give the limited relief dollars we have to tenants that are still in possession. Next slide, please. Is this the Q&A? No, not okay. Watch for future developments. Again, if you go to the statewide site that Lily showed earlier, you'll see the forms for application. There's actually some PowerPoint presentations that really drill down beyond what we were capable of doing today on both the SB 91 protections on the one end, as well as the rental assistance pathways if you're eligible only for state funds. And again, keep in mind, if you've got county or local funds, you got to go there first. Fremont has 7.1 million. So get in line now, get in line early, and try to qualify for your tenants. This is actually out of date. I have to change the bullet point. CDC moratorium was just changed 2 days ago. Mr. Rosenberg was right. I think it was him that pointed it out. It extends to June 30th with certain exceptions. I know there may be a pending lawsuit about the efficacy or the authority of CDC to impose nationwide moratoriums. There is language there that says it doesn't apply if the state or the locality provides protection of equal or greater protection to tenants. So it's a really real open question whether a tenant, I would argue that the protections here are probably greater to tenants than the CDC moratorium. But if a tenant gave you a declaration out of the blue on day 25 after you gave them a 15-day notice to pay rent, after the 15-day notice period, applying the federal protection, I would say that they're no longer within the protection afforded by SB 91, but because you may not have been able to get into court quick enough or whatever, they may be able to at that point say, well, in this lacuna, this open area, this limbo, where the 15 days have passed and they didn't give you the declaration of hardship, I'm going to at least try to protect myself as a tenant under the CDC moratorium and submit the federal CDC declaration that's available to say that I'm impacted. It's very similar to the declaration of hardship under SB 91, has different wording, but again, it's basically one page and says, I can't pay because of COVID. I would urge, again, I will look at each fact separately, but that may be enough. But the counter argument might be, well, I still can go ahead because if they're really that smart, they still have greater protection to the state law because they can always file that declaration of hardship in response to my lawsuit after I serve them with the UD, unlawful detainer complaint. So my view of it, I tend to be pretty conservative when it comes to tripwires because the client has to pay twice to do the same thing. And maybe it's better to err on the side of not trying to be the test case and paying $10,000 to an attorney to be that test case, that it may just be simpler to wait until see where we are on June 30th when you have these competing moratoriums rather than trying to figure out, as I said, somebody else has said, are lawsuits pending at the state level and the federal level? There are lawsuits and they may bubble up and give us some greater clarity. We already had the passage of the American Recovery Program. That did happen. That meant that there were federal stimulus dollars, which have gone to the coffers for the city of Fremont, I believe, as well as elsewhere. And Scott, I'll answer your question about relief for commercial property. I'm going to talk about that. Thank you. Let me segue. I advertised earlier about the Fremont moratorium. There is a Fremont moratorium for commercial tenants that still applies. and it will apply until a period of time after the declaration of emergency in Fremont is lifted, for 180 days after that period of time. And a tenant, commercial tenant, if they invoke the Fremont moratorium, can defer as much rent as possible that they cannot pay until 90 days after the declaration of emergency has been lifted in Fremont, where they have to pay 50% of the rent due, and the remaining 50% within 180 days after the declaration of emergency is due. The Fremont commercial moratorium applies only to small businesses as defined in the Fremont ordinance, which are businesses which generated annually no more than $8 million in gross revenues. There are moratoriums in Santa Clara County and in other cities, in San Mateo County as well, that talk about small businesses as defined by the Small Business Administration, federal regulations. And there's actually a matrix of, depending upon which industry you're in. So you can have, in our view, very large businesses hauling down $25 to $30 million a year be defined as a small business under the Small Business Administration that would qualify. And there's, I think in Hayward, they've got a commercial moratorium that says any commercial tenant, regardless of whether you're a franchise or regardless of the business, can qualify for moratorium relief, which means as long as you're paying all that you can pay, in good faith, the tenant cannot be evicted for non-payment. Is there rental relief? Is there relief programs available for commercial businesses? The answer is, I don't know, Scott. I'm going to be candid. I have not looked at the American Recovery Plan. I know there was small business protections given to restaurants. So I would suspect if you have a tenant that's in the restaurant industry, they're going to get money that's going to help pay to keep them from being evicted from their tenancies, to keep their business in play, even if they've been having lockdowns. But across the board, there may be things in that, $1.9 trillion program that I haven't heard about yet, but I would think that we keep our ear to the ground and see if there's ways of doing that. There may be some pot that you can tap into. Before that passed this month, the only thing that I was doing, there was Scott Wiener is a state senator that had I thought a very smart, small business friendly legislation that he couldn't get out of committee at the state Senate level, and it never even went to the assembly. But there are some arguments. I've represented commercial tenants since the pandemic, negotiate with landlords. There may be arguments that there's been, if they try to evict you, that we're in its force majeure. These are external regulations. It's like an inverse condemnation. I can't utilize my space because I'm not essential, or because the pandemic rules allow me not to utilize the space. I shouldn't have to pay rent for something that the law prohibits me from using. And so there have been efforts by some commercial tenants to raise these as defenses. I think I haven't seen them play out because it takes a while for cases to go to trial. But I think that those are valid defenses. And I've utilized those more as negotiating positions with landlords to say, as I say, I'm going to say to you, for your two landlords now, if you've had good tenants, if you've had a good tenant, you don't want to have a multitude of vacancies. That depreciates the value on a per square foot cost basis for your rental. Becomes there's a section of businesses that I've seen off of Central Avenue near Thornton, which used to be all full, and now it's got graffiti on it. And it looks like looks like a little bit of a war zone. That, I'm sure the market rate for those places has gone down considerably. There's going to have to be a lot of tenant improvements, and the landlord may have to clean up the whole site. So I'll have to answer Alice. I'll have to read the question later. I'm going to finish up here. So the argument I make on behalf of the commercial tenants is you want continuity. Try to give us, let's go beyond the Fremont moratorium. Use that as a floor and not as a ceiling. And in one case, I was able to negotiate a redemption or a relief from past payments that were not due. And then we've agreed to time going back to market rate of rent after the moratorium is lifted in Fremont. And then we're going to look at triple net, because the triple net was out of balance with what the actual use of the spaces were in comparison with some of the other tenants that were disproportionately using triple net benefits beyond what they were having to pay as compared to my compliant client who was basically subsidizing the triple net. So I use these arguments more for negotiating purposes, and the same way you should approach your tenants here, that you really should treat with kid gloves your tenants that have been what I call the golden tenant. If you've had a tenant for a year or two and they paid regularly, and it's only because of COVID, because of they're stopping payment, and they're not trying to take advantage of the situation. Really, I know it's hard for you. You need the money and the cash flow as well, but see if there's a way out so that they can work to gain back on their feet after they get their jobs back, after the pandemic is lifted, because finding a good tenant is hard, and the cost, the marketing, especially now, is in most cases not worth it to try to find a better tenant, and you can't anyways, given all these tenant protections. So what other things to look for on June 30th? Again, my bullet points are out of date because I prepared the bullet points before March 29th, where the CDC extended everything on the evictions at least through June 30th, not until September 30th. Governor may extend his authority for local jurisdictions to enact, amend, or extend existing commercial moratoriums beyond June 30th. It was supposed to expire today, March 31st. That had been there for a couple of months. A couple of weeks ago, he extended it June 30th. So these are the things to look for. And I think this is my last slide, isn't it? Then I'm ready for Q&A.
Yeah.
There we go.
Yeah, we have a question from Jason. Yeah, very specific. So he's saying, are we protected from eviction? Our landlord is harassing us to move out so they can get more rent. We only need to stay until June 1st. This is so stressful. Our landlords are so rich, but there are not enough money in the world to make the miserable souls happy. That's specific.
Well, again, if the tenant has suffered from COVID and it can truthfully submit the declaration, he can stay there to June 1st. And the landlord, if this is a residential tenant, the landlord should consider himself lucky as the landlord, because his tenant will be out before June 30th, before the moratorium ends. And at that point, if the tenant doesn't pay, yeah, it's probably going to be a consumer debt, but at least he then has vacancy decontrol and he can go out and try to rent it to a new tenant. So he shouldn't be harassing this tenant. He should be leaving him alone.
And then the other question was, the CDC extended the federal eviction ban through June 30th yesterday. What about Santa Clara County?
The CDC moratorium is nationwide. So it applies to Santa Clara County as it applies to any other county. But as I said, it's a little bit different in California because of SB 91. Arguably, the moratorium doesn't apply in California because the SB 91 might provide more tenant protection than the landlord. This is an example of where I was trying to answer a question, but it's a lot of information. So I'll repeat myself a little bit here, but I think it because there's a lot of unknowns. As I said, if a tenant does not submit a declaration of hardship within 15 days after service by the landlord for non-payment of rent, he's out in the wilderness. He no longer has all the benefits of the protection. And in theory, the landlord can then go into court and serve him with an unlawful detainer complaint. Well, in that window period between day 15 and even as he's going into court, the tenant could give him a CDC eviction and say, I'm covered under the CDC moratorium. And in that moment in time, he's got greater protection right then than he would under this SB 91. And so maybe the moratorium applies. I just think that regardless of which county you're in, it's probably best to try to maximize the rent that you can get from your tenants to see if they qualify for rental assistance if they're 80% of AMI or below, and to work with them in trying to collect as much rent as possible without harassing them, and wait until June 30th before everything lifts, and not try to say, well, maybe the CDC moratorium applies or it doesn't apply. You don't want to be in that. There are penalties and sanctions if you violate the CDC moratorium, and you can be pretty well guaranteed that if the tenant had some resources, or even if they don't, I can tell you in Alameda County, there is a organization of tenant right advocates that have a bank of attorneys, like 6 or 7 of them, that don't charge the tenants anything at all. They get grant money from United Way or from other sources, and they act as, they'll take everything to trial, and they'll throw the kitchen sink at you in terms of all the possible defenses that a tenant may have. So clearly the tenants attorneys are going to be really wired as to the CDC moratorium, and may throw those defenses in there as to intimidate a landlord. So again, it is March. I know April, May, and June is 90 more days. It's a long time, but given that it's so easy to invoke a protection or SB 91 with a one-page declaration without documentation, unless you're a high-income tenant, I would err on the side of holding off until June 30th.
Thank you so much, David. So there is another one. Are there any lawsuits against the state for taking off property? Which is?
I don't know of any currently. There was a lawsuit that was filed against the California Judicial Commission for its statewide moratorium, and it was actually filed down in Southern California. And I don't know what motivated the Chief Justice explicitly. Her public comments were basically her intent, and I believe her actually on what she said. She was acting kind of like the adult in the room. You have legislators that were looking to localities to try to take care of the problem. They didn't want to have to do the heavy lifting on compromising between landlord and tenant groups. And basically she gave notice to the legislature that she's lifting the moratorium, and if there's no local moratorium in place, the tenants are going to be out of luck, and she's done with her order. So was it motivated by the lawsuit? I don't know, but the legislature finally got its act together. It's like students having a final exam and cramming for it the night before. Our state legislature passed CTRA AB 3088 with 10 minutes to go before the clock ran out on the legislative calendar. It was signed by the governor as urgency legislation. So there may be some laws now under SB 91, under CTRA SB 91. I don't know of any at this point.
Okay, so there is another one from Scott. Do you anticipate any relief for commercial property, landlords or tenants?
I was answering Scott in real time. I did try to answer his question. I don't know of any explicit assistance to tenants in the same way for commercial tenants as there are for residential tenants. I do know that as part of the stimulus package that passed, there was relief for restaurants. So I would think that if you're a commercial tenant in the restaurant industry, you're going to be positioned to find the equivalent of PPP. Let me step back. If you are any business at all and you qualify for PPP payroll protection plan, it includes rent. So if you qualify for PPP, you can apply it for rent and have that portion of your loan basically forgiven and turned into a grant. So if you represent small businesses, there is the PPP, and there's special funding for restaurants. So there are a couple of pots to look into for relief that way.
So, okay, next question from Leslie. What is landlords are using Ellis Act as a loophole to evict the tenants?
As I said quickly, and these are great questions because it allows me to repeat and emphasize something. The Ellis Act is a statewide law that, let me explain what the Ellis Act is. The Ellis Act allows landlords to convert their property and remove it from the rental market And historically, it's in places like downtown San Francisco or Oakland or LA, where a landlord wants to gentrify and upgrade and get the highest and best return on his land or her land by eliminating tenants and converting it to condominiums or starting all over and maybe building a couple of, fourplex or whatever they want to do with it. But the Ellis Act is not self-executing. In other words, it's a statewide rule that's enabling legislation, which means that it empowers localities, local jurisdictions, local cities to enact rules giving tenants certain relocation benefits, notice requirements before the conversion can go through. I'm aware that Oakland has an Ellis Act provision, San Francisco does, LA does, I don't know about San Jose, but likely you live in a jurisdiction that doesn't have Ellis Act protection. So I know that Assemblymember Lee, who happens to be the Assembly member representing the southern part of Fremont from Maury Avenue South, Santa Clara County into San Jose and Berryessa, has introduced legislation trying to eliminate Ellis Act, by which I think he's trying to help tenants not even be subject to those notices. So I don't know if his legislation is going to create additional requirements on cities that don't have any protections for their tenants, but it's meant to make it more difficult for landlords to convert residential property. So you need to look at what Assemblymember Lee Alex Lee is trying to do to see if that impacts you. But in Fremont today, I can tell you there is no Ellis Act protection for tenants. You can remove your property from real estate, sell it, do whatever, without having to go through the Ellis Act.
So next question is from Alice, and so rent lease expired during rent went up even though COVID hardship dog and 25% met. Is this legit?
San Jose has approved a rent freeze, but unless it violates AB 1482, and it might, which is AB 1482 may now apply to the rental space, even if it's owned by a mom and pop, it may not be legit. And I don't have I think it's, 5% of the CPI or 10%, whichever is less, can be the cap on an increase. So if you got an AB 1482 property as a residential tenant, and you're the tenant that's been hit with a 25% increase, it may be too high. And you could point out that we're in the middle of a pandemic. I got SB 91 in my back pocket right now, and you can't do that.
Oh, okay. So next question from Katya. So she asks, tenant has no economic hardship and landlord wants to move to renovate the house. Can landlord do that?
No. This is the situation where AB 1482 likely applies, and you can't do a substantial remodel unless a governmental agency says your house is going to be red tagged and you need to do it for public safety reasons. So you can potentially remove a tenant if you're going to remove it from the rental market. It depends upon which city and county you're in, and if there's any local rent control laws or if the Ellis Act applies. So a lot of these questions are great general questions, but a lot of these questions depend upon where you are and what laws are in place and or may not be in place that impact that decision.
So thank you so much, David. So the next question is, if a tenant has not fallen behind on rent, can they turn in DFH for the entire duration in event they fall behind? They do fall behind.
I didn't understand that question.
Yeah, me too.
Where is it? I don't know what DFH is. Department of Fair Employment and Housing? DFEH? Who asked the question? Where is it?
The nickname of advocate. So if a tenant has not fallen behind on rent, can they turn and defect the entire duration? It's oh, I think declaration of financial hardship.
Could you repeat the question, please? I didn't understand the question.
Oh, okay. If
Oh,
a tenant,
DFEH stands for Declaration of Financial Hardship. Okay, got it. Okay. Now, okay, so repeat the question. I got stuck at DFH.
okay, if a tenant has not fallen behind on rent, can they turn into DFH for the entire duration and event they do fall behind?
Can they use, in other words, I'll repeat the question as I think what they're asking is, can they use the Declaration of Financial Hardship kind of like as a protective device in case they fall behind later? I don't think you can. I think that because if you're not falling behind, you're lying in your declaration that you can't pay because you're paying rent. Okay, so it's very sequential. The law is if this, it's like it's an if then kind of software program. The law says a tenant hasn't paid rent. A landlord then sends out a 15-day notice to pay rent or quit and includes the hardship. So you look at that point in time and the tenant says, I can't pay rent, and then truthfully can submit the DFH or Declaration of Financial Hardship at that time. But you cannot just say, hey, look, and I might in 3 months lose my job and I want to be able to proactively have this in my back pocket so you can never evict me at least until June 30th. It doesn't work that way.
Thank you so much. If landlord, this question is from Jason. If landlord attempted to evict a residential tenant, how long does it take to get a court date? 90 days? Question.
Well, that was the interesting thing about landlord-tenant law, was that it's entitled to statutory preference because historically the property rights of landlords predominated, and that what you're doing with a lease is separating ownership with the right to possession by allowing a tenant under the terms of a written lease to be able to occupy the premises under those constraints. Right now, if you're in Alameda County, the local rules basically prevent you from doing it unless it's falling within one of those limited exceptions. So you no longer can use non-payment of rent unless somebody's completely blowing you off on the Declaration of Financial Hardship as a basis for evicting. Having said that, the courts, and there's now a new form that you have to go through for the courts to look at to see if you qualify for being able to pursue it. But basically in Alameda County, you can't get into court for non-payment of rent right now because of the Alameda County ordinance. So it doesn't, it's a hypothetical question. In other counties, I don't know for sure, but typically it's 60 to 90 days. Obviously, if the tenant defaults, then you get a default judgment a lot sooner. And then, Jason, you've actually raised another question or a potential issue. You got to look at when you get to an end, when the landlord gets a judgment in their favor, if and when a landlord gets a judgment and has the right under the judgment to possession as part of the judgment, that's a nice piece of paper for the landlord, but it doesn't do anything if the tenant refuses to leave. The tenant, in order to assure that the tenant leaves, the landlord will obtain what's called a writ of possession. That writ is issued by the court, and then it is delivered to the county sheriff. Well, I can tell you, and I don't know if this is true recently, but county sheriffs up and down the state say, we've got a pandemic on our hands. We don't want to be involved in congregate events where we're having to contact people unnecessarily. We don't think evictions are very high priority. So you might get the writ of possession from the court, and the sheriff's department puts it in a folder and doesn't do anything with it. So you can have that. So you can get your judgment within 60 to 90 days. But if you're a landlord, a tenant may be able to stay there for a couple more months until the pandemic is lifted, and the sheriff's department on their own determine that they're going to enforce these writs of possession. So there's a lot of twists and turns right now.
Thank you. So another question from Jason. Our landlord has put the entire parcel with 2 homes up for sale. Can they use that as an excuse to evict us? Would they need to pay relocation for us to leave? And how much time would we have legally to move? Wow.
Again, This goes back to whether you're in an Ellis Act jurisdiction or not. And I don't know. If it's not Ellis Act, if it's Fremont, that can be a legitimate basis to go into court and remove the property from the rental market. And if you've been living there for at least 12 months, you're entitled to a minimum 60-day notice. And the landlord will likely have to comply with AB 1482, which means that they will have to state that explicitly in the notice in order to invoke that right, and entitle and give you relocation benefits, which are in the form of either forgiving 1 month's rent or paying you the equivalent of 1 month's rent. That's AB 1482 in confluence with SB, as it's converging now with SB 91 to go through the right routine. And hopefully, if you're the landlord, I mean, if you're the tenant, they may not be able to do it right. And then you either point it out before they go take you to court, or you have an attorney point it out before they take you to court, or after you've been served with the unlawful detainer, and then they'd have to start all over again.
Oh, and another question from, thank you so much, David. I'm sorry, the questions keep coming. So from Marina, not about eviction. Is it possible tenant have broken one kitchen cabinet door of the old kitchen? Can the landlord ask the tenants to replace all the kitchen cabinets? That's
well, they probably can ask it, but I don't think there's any enforcement mechanism. You certainly can't say, if there's an affirmative covenant to maintain the kitchen cabinets, I don't think you have any obligation under an ordinary lease to replace. You have a duty to repair. And so if there's one kitchen cabinet door that's not working, you have to replace the kitchen cabinet door. It is not fair for a landlord to require a tenant to do an upgrade, typically.
Thank you, David. So I think that's all questions.
Okay, and again, I want to thank well, I mean, if there's no more questions, I'll just wrap up again saying that if you wish to share my PowerPoint with everyone, that's fine with me, Ms. Garipova, and if people want to get in touch with me, that's fine as well. I have some friends here that are a part of the 15. Nice to see you remotely, virtually for the first time in a while. And Ms. Garipova, I thank you for hosting me today.
Oh, okay. Thank you so much, David. Thank you. It was very actually educational, and there is always room to learn. There
is. And I was waiting, I was waiting for the Russian translation because I was going to say "Das Vidanya," which means goodbye in Russian for all the people that don't speak Russian. So I wanted to hear a little bit of Russian from you.
This is great. Das Vidanya. Yeah.